Good evening and thank you for joining me this evening. Today I want to talk about the grounds for which you can have a divorce in Nigeria if your marriage is less than 2 years old, right? The grounds for which you can have a divorce within 2 years of marriage in Nigeria. And I hope that the information I will share with you today will be helpful. Remember that this is not legal advice. This is just me sharing with you my knowledge, my understanding, and the experiences that I get to have with clients' cases and with other people's cases in court. My name is Earl and I'm all right, and I'm your family lawyer and also your family therapist, right? Okay, now I would like to clarify some things. Number one is that the marriage I'm going to be talking about on today's discussion happens to be the marriage under the Act, the marriage that is contracted under the Marriage Act, right? So if we're talking about the Marriage Act, we are talking about statutory marriage, marriage that you have either at a marriage registry, which people generally call court marriage, or the marriage that you have in a church that is licensed for marriage. These are the things we're going to be focusing about today. These are the things that I want to share with you, and I hope you're able to get the understanding, right? Generally, based on our Marriage Act and our Matrimonial Causes Act and rules, once your statutory marriage, the one you call court marriage, or the marriage that is in a church that is licensed for marriage, once you have that kind of marriage, you cannot divorce within 2 years. You have to be married for 2 years before you can come to court and say, hey, I want to divorce. I'm tired of this marriage, or there are things happening in this marriage and I know they do again. You get it now? The marriage has to be for at least 2 years. However, although that's a general principle, we all know that to everything there is an exception. And yes, to that principle, there is an exception. There are situations in which a person who is married for just 1 month, 1 year, 1 day, can choose to come to court and say, I need permission to file for divorce, right? The law actually requires that if you want to pull out from your marriage within 2 years of your marriage, you need to seek the permission of the court before you can continue with that, right? So, but the grounds for it, I checked the grounds again. Although I've been a lawyer for about 12 years and this is what I get to do almost every day, I checked the grounds again. It was amazing that we have about 14 grounds, right, stipulated by the law on which any person can come up to say, hey, I'm not marrying this person again. Yes, I chose to marry this person before, but see, I know they do again. I don't tire, right? And you can do this within 2 years of that marriage. The first one is where either the husband or wife was lawfully married to another person at the time of the marriage. I would like to explain this. Under the Marriage Act, you cannot marry any person. You don't have a valid marriage with any person when you are still married to another person, right? I'm going to explain this and try to bring up the exceptions so you get to know and see the difference. What does it mean? If A is married to B under customary law or under the Marriage Act, and now goes ahead to marry C in a court marriage, right? In a marriage registry, in a church wedding, right? If A does that, when C notices that, oh, A has been married before, and that marriage, he did not end it, he did not divorce. The moment A notices that, A can come up, the moment C notices that, C can come up to say, hey, I want to pull out from this marriage. This marriage may only be 1 month old, but it was predicated on something wrong. It was founded on something unlawful, right? Now, you should know the difference. If a man has been married to A, if Mr. A marries Miss B under customary law, marries Miss C under customary law, and goes ahead to do statutory marriage, that is marriage under the Marriage Act with only C, maybe goes to do registry marriage with only C, right? It's something we get to see a lot in Nigeria. People who are polygamous, they see one wife convincing the man, or the man wanting to pepper the other wives, decide to carry one and go and do registry marriage with that one. That marriage, that registry marriage is null and void, right? In fact, it is more or less like as if that the marriage does not exist. It is null and void. That is not what the law is contemplating in this particular situation. It is that A marries B, whether by traditional customary law or by statutory law, then goes ahead and marries C again under statutory law, under the Marriage Act. Most of the time, C, not knowing in the first place that A was married to somebody else. You get it now? You see how it works, right? Okay, now let's go to number 2, where the requirements for the proper solemnization of the marriage were not followed, e.g., ceremony performed by an unlicensed person. Yes. Now, by law, if you must marry, it's between a particular time, most especially 8 a.m. and 6 p.m. of the day. If someone want to have night wedding, they want to have night journey, so they want to do their journey around 8 p.m. and the rest, the law does not agree to that. Or for example, you have registry marriage, you guys have a marriage in church or wherever, and it's outside the stipulated lawful time, or it was by somebody who was not licensed to do that marriage, you can come up and say, hey, we want to divorce because what we have was not properly done. So what number 2 is actually saying is that you can divorce within 2 years if your marriage was not properly done. The steps to be followed were not properly followed. Like for example, it was supposed to be you are supposed to file at the registry, wait for the number of days, 21 to 28 days, before you come back again to say you're getting married. And those processes were not followed, right? Once the legal process required for you to have such a valid marriage was not followed, you can come up and say, I'm not a do again. I want to divorce, right? Okay, number 3, where the consent of either of the couple was obtained by duress or by fraud. Right? By duress or by fraud. Like when you force somebody to say, oh, because you are owing me money, oh, so that I don't blackmail you or blackmail your family, or by deceit, right? You try to do something to coerce this person into marrying you. That person can come up over a month later to say, I want to divorce. I've come to my senses, I've come to my realization that this person wanted to marry me just to get visa. That this person just wanted to marry me just to be able to relocate to Japa. Or this person wanted to marry me just for the social hype and the rest. I have come to realize it. It was through duress or it was through fraud. I was deceived into this. I was coerced into this. I was forced to do this. Once you're able to establish that, then yes, you can divorce within 2 years of that marriage. You don't have to start waiting for the 2 years rule to elapse. Remember that what I'm sharing here today are the grounds for which on which a person can divorce within 2 years of statutory marriage, right? And we established earlier on that marriage has to do with marriage under the Marriage Act, which was either conducted in a marriage registry, a licensed church, or in a place licensed by the governor of the state for that particular marriage. So I will continue. I've talked about number 1, number 2, number 3, and now I'm in number 4, where there was a mistake as to the identity of the other party or the nature of the ceremony performed. Remember, number 3 has to do with consent, like where somebody did not consent to the marriage genuinely or wholeheartedly, but it was induced by that duress or fraud. But this time we are talking about where the identity of the other party or the nature of the ceremony, there was a mistake in it, right? So for example, I thought that I was marrying A, not know that who I was marrying was B. Maybe because they are twins or because they look alike, or because maybe customarily I was not there, so I told his family to just go and perform the rites with my family. Yes, because under customary law in Nigeria, the groom must not be present for a customary marriage to be valid, right? Maybe there's a mistake in the identity of the person, not just a mistake in the identity of the person in this case, but also in the nature of the ceremony. Maybe thought that the ceremony was just a party. Or you even thought that it was introduction, not knowing that it was the marriage gone gone. Right? So you were mistaken about the nature of the ceremony that was being held. Of course, you can come up to say, I know they do. I want divorce, right? I want to divorce right away. Another one, which will be number 5. Remember, we are going to 14 reasons. So stay glued. You may just find a reason that will be useful to you or to someone you know, either now or in the future. Number 5 says, where one party was mentally incapable of understanding the nature of the marriage contract. This may have to do with mental health, psychiatric health, right? This may have to do with maybe your age, your inability to mentally understand. Maybe at that particular time, it was a time when you were dealing with a particular mental ailment, you were dealing with a particular mental situation, so you could not actually know clearly or understand clearly the ceremony that was being performed. You could not have known that it was marriage that was being performed. Yes, so they may say, did you not know that it was marriage? That, oh, of course it was marriage and all of that, but at that particular time, at the time the ceremony was performed, due to mental health reasons, you could not have known. You did not know, right? That's an excuse for you to divorce within 2 years of marriage. Okay, I'll go further. Number 6, where either of the parties is not of marriageable age. It should be noted here that the Nigerian Constitution does not establish a minimum age for marriage, right? So the Child Rights Act, which was passed in 2003, sets the age of marriage at 18 years old. However, only 23 of Nigeria's 36 states have adopted this act. As a result, in some areas of the country, the minimum age for marriage can be as low as 12 years old. So let me do all the breakdown so that you get understanding. Generally, under customary law in Nigeria, puberty is the age of maturity, of adulthood for marriage. Once you have attained puberty, right? So that's the customary practice in most traditions, most customs in Nigeria. Then until we had the Marriage Act. By the Marriage Act, for you to marry under the Marriage Act, you must have been 21 years old before you can choose to say you want to marry by yourself. However, if you are 18 years old and above, if you are 18 years old, between 18 years old and 21 years old, you will need your parental consent or the consent of your guardian before you can marry under the Act, before you can marry at a marriage registry or at a church. So between 18 and 21, you will need the consent of your parents or your guardians. However, once you are 21 years old, you don't need any person's consent. You can go by yourself and say you want to marry. That's what the Marriage Act says. Now, the Constitution does not give an age when you can marry. However, there's now what we call the Child Rights Act. The Child Rights Act now says that, remember I mentioned earlier on that according to our tradition and customs, a person can ordinarily marry once the person has attained puberty. But the Child Rights Act came up and changed the policy and said, no, you cannot just marry because you have attained puberty. Any person that can marry must have gotten to 18 years first. So even if your parents are consenting, your parents don't have the power to consent if you are less than 18. You have to get to 18 years first before you can even do customary marriage. So the Child Rights Act stopped it from puberty and made it 18 years. Of course, some children reach puberty at 9, some 8, some 13, some 15. So the customary law is not so fixed. So it is whenever you hit puberty and start puberty, you are mature for marriage. But the Child Rights Act says no, puberty or no puberty, you cannot marry under customary law or statutory law until you are 18 years old. However, The Marriage Act is a federal act. So it only governs Abuja. Why? Because things that have to do with children, it is not only the National Houses of Assemblies that has the power. The State House of Assemblies have the power to also make laws for their state. So the Child Rights Act is for Abuja people. It's a federal law. Every state is required to make their own child rights law, to make law that govern children in their states. That Child Rights Act, only about 23 states have adopted that law, right? Not all the 36 states yet. Only about 23 and more thereabout. So what it means is that for those states where the child rights law has not yet been domesticated, puberty can still be the age for marriage in those states. For some of those states, they have other laws that put it for like 12 years old, right? Now, maybe you live in a state, or this person lives in a particular state where the law forbids any person from getting married who is less than 18 years old. And this person got married at the age of 17, maybe 17 years, 9 months, or 17 years, 11 months. The person can come up within 2 years of that marriage and say, I want to divorce. And what's your ground for divorce? I was married off as a child. I married as a child. Do you understand it now? So that is what you should get it. You should get there. Or maybe the person went to do the marriage himself and was not yet up to 21 years old, as at the time the marriage was conducted, and yet parental consent was not given. Let's go to number 7. We've got to number 7, which is half of everything I'll be sharing today. Remember, I said there are 40 grounds, and this is number 7. Number 7 talks about where both parties are within what is known as the prohibited degrees of consanguinity and affinity. The prohibited degrees of consanguinity and affinity refer to a list of relationships which are not allowed by law to marry, e.g., brother and sister, uncle and niece, right? Now, there's something I want you to understand regarding this, is that in Nigeria, and based on our laws and the Marriage Act and the rest, there are some people that cannot marry because of their blood relationship, either because of their blood relationship or because of their marital relationship, right? So, for example, a man and his stepdaughter cannot marry, right? A boy and his stepsister cannot marry, right? So there are some of those relationships and some of those things wherein these people cannot, you cannot marry. So if any person marries based on that, the person can come up and say, hey, I want divorce. I did not marry properly. I married my relative. I married my friend, right? So that can also apply. Now, let's go to number 8. Where at the time of the marriage, either party was incapable of consummating it. E.g., the husband is suffering from some form of erectile dysfunction. I have witnessed this. I've seen this in court. And of course, recently, it trended in Nigeria of a lady who said he was a GO's daughter, married a man, and in the marriage discovered that the man had no penis. We have seen many situations in which somebody marries a person and discover that, oh, the person has erectile dysfunction, or the person, we have seen situation where somebody married a lady not knowing that she was transgender, and the rest, right? So, in that situation, you can come up with the next day, or 2 days after, or 3 days after, and say, you see, this person I'm married to, it's not somebody I can have sex with, or it's not somebody that can have sex with me, or is somebody who is refusing to have sex with me, deliberately and willfully refusing to have sex with me. If you are in that situation, if a person is in that situation, the person can come up and say, yes, I want to divorce, even though the marriage is just 1 week old, or 1 month old, or 3 months old, right? Okay, so let's go to number 9. Where at the time of the marriage, either party is of unsound mind, a mental defect or subject to recurrent attacks of insanity or epilepsy, right? The way I usually put this is, I will say, if there's anything you know, especially when it comes to your health, especially when it comes to your health, and when it comes to your secrets, and when it comes to your life, if there's anything you know that will make B not to marry you, and you refuse to tell B, if B marries you and finds out that thing in 1 month, B can come up and say, I'm not doing it again. Right? Because you withheld information. That will fall under fraud. That the person, you married the person under fraud. You were brief fraudulent about your reality. Right? So if the person is on sound mind, or there's a mental defect, or the person is subject to recurrent attacks, or the person has an epilepsy, you can come up within 2 years and say, hey, I'm not doing it again. Especially when you did not know about that reality before the marriage. Okay, number 10. We've got to 10 out of 14. Good one. Thank you for staying on. Where at the time of the marriage, either party is suffering from a venereal disease, in a communicable form. This will include all sexually transmitted disease and infections. And especially when that sexually transmitted disease and infection was not from you. You can come up and say, I noticed that this person has this particular ailment, this particular disease, and I'm not willing to marry the person again. And I want to work and I want to live. Yes, on that ground, you can divorce within 2 years. Okay, number 11, we are at the time of the marriage, the wife is pregnant by a person other than her husband. You know, in Nigeria today, we are having this major issue of paternity fraud. And Nigeria has been rumored to rank number 2 in the world when it comes to paternity fraud. Interestingly, when it comes to paternity fraud in Nigeria, it is said to be highest among people who are firstborns. And for interaction that I have with people as a family law lawyer and also as a therapist, I notice that people are usually have what we call this breakup sex or last sex, which makes it most of the time that the firstborn children of a good number of homes are by the woman's ex. Right? The woman's ex is the father of the child and not the man. Right? So in that situation, if you as a man realizes that your wife is pregnant for someone who isn't you, your wife is pregnant for another person who isn't you, and you are not the one who's responsible for that pregnancy, you can come up and say you are divorcing. Right? Why should I still marry you and father your child? Father the child of another man, or condone your adultery. Right? That is a ground. Okay, number 12, where the other person has refused to consummate the marriage. I said this earlier on when I was talking about number 8, where at the time of the marriage, that party is incapable of consummating the marriage. This one, number 12, is when this person is saying, no, I don't want to have sex with you. I remember a case like that, customary court, Makodi, several years ago. That should be 2012, or sorry, 2013. Yes, that should be about 2013, if I'm not mistaken. And what was it? The man kept on saying that that the woman's body is too hot and all of that. Okay, and he would always sleep on the floor, or he would always sleep here, or he would always pick up one excuse or the other why he would not have sex. So the lady came to court and requested for divorce. Number 13, where the other party has committed adultery. See, in northern Nigeria, adultery is a crime. In southern Nigeria, adultery is a civil wrong, right? So if you commit adultery within the first 2 years of your marriage, your spouse can rely on that adultery to say, I want to divorce. Your spouse can rely on that adultery to pull out from the marriage. So you should take note of this. It's a ground for divorce even within 2 days of the marriage. Then lastly, number 4, where the other party has committed acts or rape, sodomy, or bestiality. If a spouse has committed some major crimes, right, like a felony, has created, committed major crimes, and the rest, a person can come up and say, no, I don't want to marry. I don't want to be married to this criminal. I want to leave. Right? It may not be listed here because what is listed here is acts of rape, sodomy, or bestiality. But I can tell you that if armed robbery is part of that, if murder is part of that, and some other crazy cases are part of that, I'm sure the court will want to consider. I'm sure the court will want to consider, like, no, I don't think I want to continue living my life with this kind of person or be married to this person. These are the 14 reasons and 14 grounds on which a person can stand to have a divorce within 2 years of a statutory marriage. Remember, like I said, that this is not legal advice, so I want you to consult with your lawyer to get the best counsel regarding your matter. And if you want me, because I'm a lawyer, to attend to you, you can send me a DM or use the details showing on the screen or in the description section to contact me. Thank you so much for following. Next week, I'll be back here to share another thing amazing on family law, from family law, that you can learn from. Every Tuesday, let's come here and let's learn together. My name is Earl, I'm all right, and from the city of Ibadan, Nigeria, you rock.